Hello everybody, Andrew Reed here, and welcome to part 17, the final part of my NCA exam study guide for constitutional law for the 2023 exams. And we're going to take a look at part 17 here. This is remedies. So this is where the courts have found a constitutional violation in either a law or an action by the government. How can they correct this? So looking at section 24 of the Charter, anyone whose rights or freedoms as guaranteed by this Charter that have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. And also, there's an exclusion of evidence clause in here. A court, so where in proceedings under this subsection, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by the Charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. Also affecting remedies is Section 52 of the Charter, which says that regarding the primacy of the Constitution of Canada. So the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Constitution of Canada includes Canada Act of 1982, the acts and orders referred to in the schedule, any amendment to any act or order referred to in these paragraphs. And amendments should only be made in accordance with the authority contained in the Constitution of Canada. So we're going to take a look at three different cases. Not necessarily entire briefs, but just looking at the parts of these cases in which they're applying remedies. And the first one, possibly the biggest, is Vriend, V-R-I-E-N-D, v. Alberta in 1998. So the judge goes on a lengthy exploration of the relationship between the legislators and the courts under the Charter. And here are some excerpts from that. Number one, each Canadian was given individual rights and freedoms, which no government or legislature could take away. However, as rights and freedoms are not absolute, governments and legislatures could justify the qualification or infringement of these constitutional rights under Section 1, as previously discussed. Inevitably, disputes over the meanings of the rights and their justification would have to be settled, and this is where the court systems come in. Many countries have assigned the important role of judicial review to their supreme or constitutional courts. Canada is no exception. So, courts, in their trustee or arbiter role for the Constitution, must perform and scrutinize the work of the legislature and executive, not in the name of the courts, but in the interest of this new social contract that was democratically chosen, referring to the Constitution. All of this is implied in the power given to the courts under Section 24 of the Charter and Section 52 of the Constitution Act of 1982. So the first step in selecting a remedial course under Section 52 is to define the extent of the Charter inconsistency, which must be struck down. So the next step is to determine which remedy is appropriate. In Shaster, the court noted that depending on the circumstances, there are several remedial options available to a court in dealing with a Charter violation that is not saved by Section 1. These include striking down the legislation, severance of the offending sections, striking down or severance with a temporary suspension of the declaration of invalidity, reading down, and reading provisions into the legislation. The Charter violation in the case that they're referring to in this Vriend case stems from an omission. The remedy of reading down is not available for an omission. The judge also notes that the considerable number of sections at issue in this case and the important roles that they play, severance of these sections from the Act would be the same as striking down the entire Act. The appellant suggests that the circumstances of this case warrant the reading in of sexual orientation into the offending sections of the RPA Act. However, the Alberta Court of Appeal agreed that the appropriate remedy would be to declare the provisions of the RPA unconstitutional and to suspend that declaration for a period of time to allow the legislature to address the matter. One appeal judge would have gone further and declared the entire thing invalid. With respect for the reasons that follow, this judge cannot agree with either of those remedies. So in Shaster, the judge there noted that when determining whether the remedy of reading in is appropriate, courts have to regard the twin guiding principles: respect for the role of the legislature and respect for the purposes of the charter. Reading in is an important tool in avoiding undue intrusion to the legislative sphere. The purpose of reading in is to be as faithful as possible within the requirements of the Constitution to the scheme enacted by the legislature. So courts should certainly go as far as required to protect rights, but no further. Interference with legitimate legislative purposes should be minimized, and laws serving such purposes should be allowed to remain operative to the extent that rights are not violated. Legislation which serves desirable social purposes may give rise to entitlements, which themselves deserve some protection. As this judge said, the purpose of the IRPA is the recognition and protection of the inherent dignity and inalienable rights of Albertans through the elimination of discriminatory practices. So it seems to the judge that the remedy of reading in would minimize interference with this clearly legitimate legislative purpose, and thereby avoid excessive intrusion into the legislative sphere, whereas striking down the IRPA would deprive all Albertans of human rights protection and thereby unduly interfere with the scheme enacted by the legislature. Turning to the second of the twin guiding principles, which is the charter, sticking to the values of the charter, the respondent suggests that the facts of this case are illustrative of a conflict between two grounds, namely religion and sexual orientation. If sexual orientations were simply read into this Human Rights Act, the respondents contend this would undermine the ability of the Human Rights Act to provide protection against discrimination based on religion, one of the fundamental goals of that legislation, and that this result would be inconsistent with the deeper social purposes of the Charter. This judge says that there's internal balancing mechanisms built into this act that were adequate to dispose of any conflict that might arise between religion and sexual orientation. Therefore, he rejects that entire argument. This judge says reading sexual orientation into the act as a further ground to prohibit discrimination can only enhance those purposes. The Charter, like the Human Rights Act, is concerned with the promotion and protection of inherent dignity and inalienable rights. So expanding the list of prohibited grounds of discrimination in the Human Rights Act allows the Supreme Court to act in a manner which, consistent with the purposes of the Charter, would augment the scope of the Human Rights Act's protections. In contrast, striking down or severing parts of it would deny all Albertans protection from discrimination, and that would be against the purposes of the Charter. In the case of Shaster, the judge there noted that the twin guiding principles can only be fulfilled if due consideration is given to several additional criteria, which further inform the determination as to whether the remedy of reading in is appropriate. Those include remedial precision, budgetary implications, effects on the thrust of the legislation, and interference with legislative objectives. As to the first of those criteria, the court must be able to define with a sufficient degree of precision how the statute ought to be extended in order to comply with the Constitution. In cases where the issue is whether to extend benefits to a group excluded from the legislation, the question of the effects on the thrust of the legislation will sometimes focus on the size of the group to be added, as compared to the group originally benefited. The remedy of reading in was far less intrusive to the intention of the legislator in this case at hand than striking down the benefits scheme, because the group to be added was much smaller than the group already receiving the benefits. The final criterion to examine is interference with the legislative objective. The degree to which a particular remedy intrudes into the legislative sphere can only be determined by giving careful attention to the objective embodied in the legislation in question. A second level of legislative intention may be manifest in the means chosen to pursue that objective. By definition, charter scrutiny will always involve some interference with the legislative will. Where a statute has been found to be unconstitutional, whether the court chooses to read provisions into the legislation or to strike it down, legislative intent is necessarily interfered with to some extent. Therefore, the closest a court can come to respecting the legislative intention is to determine what the legislator would have done, likely have done, if it had known that its chosen measures would have been found unconstitutional. This judge says that a deliberate choice of means will not act as a bar to reading in, save for those circumstances in which the means chosen can be shown to be of such centrality to the aims of the legislature and so integral to the scheme of the legislation that the legislator would not have enacted the statute without them. The process by which the Alberta legislature, according to this judge, decided to exclude sexual orientation from the Human Rights Act was inconsistent with democratic principles. Both the trial judge and all judges of the appeal agreed that exclusion of sexual orientation was a conscious and deliberate legislative choice. This judge says that a democracy requires that legislators take into account the interests of majorities and minorities alike, all of whom will be affected by the decisions they make. Where the interests of a minority have been denied consideration, especially where that group has historically been the target of prejudice and discrimination, this judge believes that judicial intervention is warranted to correct a democratic process that has been acted improperly. This is actually from the Oaks case. So that judge said this. Governments are free to modify the amended legislation by passing exceptions and defenses which they feel can be justified under Section 1 of the Charter. So when a court reads in, this is not the end of the legislative process, because then the legislator can go on to pass new legislation in response. Moreover, the legislators can always turn to Section 33, the override provision, the notwithstanding clause, which, in this judge's view, is the ultimate parliamentary safeguard. So this judge concludes reading sexual orientation into the impugned provisions of the Human Rights Act is the most appropriate way of remedying this under-inclusive legislation. Next case on the list, Vancouver versus Ward in 2010. So the issue here was whether the claimant was entitled to damages, monetary damages, as remedy under Section 24 of the Charter. And the background here, during a ceremony in Vancouver, City Police Department received information that an unknown individual threatened to throw a pie at the Prime Minister who was in attendance. Based on his appearance, police officers mistakenly identified W as the would-be pie thrower, chased him down, handcuffed him. W loudly protested, created a disturbance, was arrested for breach of the peace, and was taken to police lockup. When he arrived there, the corrections officers conducted a strip search. While W was in lockup, police officers impounded his car for the purposes of searching it with a search warrant. But they determined they did not have grounds to get a search warrant or evidence to charge W for attempted assault, and he was released 4.5 hours later. W brought an action in tort and for breach of his rights against several parties, including the province and the city. With respect to the strip search and the car seizure, the trial judge held that although the province and the city did not act in bad faith and were not liable in tort for either incident, the province's strip search and the city's vehicle seizure violated W's right to be free from unreasonable search and seizure under Section 8 of the Charter. The trial judge assessed damages under Section 24 of the Charter at $100 for the seizure of the car and $5,000 for the strip search. The Crown appealed this, but they upheld the trial judge's ruling. So then the Crown appealed it again, and now it's in front of the Supreme Court, if I understand correctly. So the rule here is the language of Section 24.1 is broad enough to include the remedy of constitutional damages for breach of a claimant's charter rights if such remedy is found to be appropriate and just in the circumstances of a particular case. Note that these rules come from this case. The first step in the inquiry is to establish that a charter right has been breached. The second step is to show why damages are a just and appropriate remedy, having regard to whether they would fulfill one or more of the related functions of compensation, vindication of the right, and/or deterrence of further breaches. Once the claimant has established that damages are functionally justified, the state has the opportunity to demonstrate, at the third step, that countervailing factors defeat the functional considerations that support a damage award and would then render damages inappropriate or unjust. Countervailing considerations include the existence of alternative remedies. Claimants need not show they have exhausted all other recourses. Rather, it's for the state to show that other remedies, including private law remedies or another charter remedy, are available in the particular case that will sufficiently address the charter breach. Concern for effective governance may also negate the appropriateness of Section 24(1) damages. In some situations, the state may establish that an award of charter damages would interfere with good governance, such that damages should not be awarded unless the state conduct meets a minimum threshold of gravity. If the state fails to negate that the award is appropriate and just, the final step is to assess the quantum of the damages. To be appropriate and just, an award of damages must represent a meaningful response to the seriousness of the breach and the objectives of Section 24 damages. Where the objective of compensation is engaged, the concern is to restore the claimant to the position he or she would have been in had the breach not been committed. With the objectives of vindication and deterrence, the appropriate determination is an exercise in rationality and proportionality. Generally, the more egregious the breach and the more serious the repercussions on the claimant, the higher the award for vindication or deterrence will be. In the end, Section 24 damages must be fair to both the claimant and the state. In considering what is fair to both, a court may take into account the public interest in good governance, the danger of deterring governments from undertaking beneficial new policies and programs, and the need to avoid diverting large sums of funds from public programs to private interests. Damages under Section 24 should also not duplicate damages awarded under private law causes of action, such as tort, where compensation of personal loss is at issue. So an analysis based on these rules. Here, damages were properly awarded for the strip search of W. This search violated his Section 8 charter rights, and compensation is required, in this case, to functionally fulfill the objects of constitutional damages. Strip searches are inherently humiliating and degrading, and the charter breach significantly impacted on W's person and rights. The correction officer's conduct, which caused this breach, was also serious. Minimum sensitivity to charter concerns within the context of the particular situation would have shown the search to be unnecessary and violating his rights. Combined with the police conduct, the impingement on W also engages the objects of vindication of the right and deterrence of future breaches. The state did not establish countervailing factors, and damages should be awarded for the breach. Considering the seriousness of the injury and the finding that the correction officer's actions were not intentional, malicious, high-handed, or oppressive, the trial judge's $5,000 damage award was appropriate. With respect to the seizure of the car, W did not establish that the damages under Section 24 are appropriate and just from a functional perspective. The object of compensation is not engaged, as W did not suffer any injury as a result of the seizure. Nor are the objects of vindication of the right and deterrence of future breaches compelling. So while the seizure was wrong, it was not of a serious nature. A declaration under Section 24 that the vehicle seizure violated W's right to be free from unreasonable search and seizure under Section 8 of the Charter adequately serves the need for vindication of the right and deterrence of future improper car seizures. Final case under Remedies is Ontario versus G 2020. So here I've just grabbed some rules from this case and some analysis related to the remedies. The rule, the determination of appropriate remedies for legislation that violate the Charter must follow a principled approach. Section 52(1) of the Constitution Act in 1982 provides in absolute terms that laws inconsistent with the Constitution are of no force or effect to the extent of the inconsistency. A general declaration is the means by which courts give full effect to the broad terms of Section 52(1). A court faced with a constitutional challenge to a law must determine to what extent it is unconstitutional and declare it to be so. A measure of discretion is inevitable in determining how to respond to an inconsistency between legislation and the Constitution. While Section 52(1) recognizes the primacy of the Constitution, including the fundamental rights and freedoms of individuals and groups guaranteed by the Charter, fashioning constitutional remedies inevitably implicates other, at times competing, constitutional principles. Courts must strike an appropriate balance between those principles in determining how to give effect to Section 52 in a manner that best aligns with Canada's constitutional order. The court's leading decision on remedies for laws that violate the Charter is Shaster, which provides helpful guidance on how to craft a responsive and effective remedy for unconstitutional law. Shaster sets out a general approach to granting remedies. It endorsed remedies tailored to the breadth of rights violations, thereby allowing constitutionally compliant aspects of unconstitutional legislation to be preserved. And the case recognized that, in rare circumstances, the effect of a declaration of invalidity could be suspended for a period of time to protect the public interest. Shaster also considered how Section 52 remedies could be combined with individual remedies for charter violations, including whether the claimant should receive an individual exemption from a suspension, thereby ensuring that successful claimants can enjoy the immediate benefit of a declaration of invalidity. By employing and building on Shaster's guidance in determining the form and breadth of declarations of invalidity, suspending the effects of those declarations, and exempting individuals from suspensions, the court's jurisprudence has coalesced around a group of core remedial principles that structure the exercise of principled remedial discretion and provide the groundwork for meaningful remedies in different contexts. First, safeguarding rights lies at the core of granting charter remedies because the Charter exists to protect rights, freedoms, and inherent dignity. Second, the public has an interest in legislation that is constitutionally compliant. Third, the public is entitled to the benefit of legislation which individuals rely upon to organize their lives and protect them from harm. Fourth, courts and legislatures play different institutional roles. The legislature is sovereign in the sense that it has exclusive authority to enact, amend, and repeal any law as it sees fit, while courts remain guardians of the constitutions and of individuals' rights under it. These principles provide guidance to courts and encourage them to transparently explain remedial results. As the language of Section 52(1) directs, the first step in crafting an appropriate remedy is determining the extent of the legislation's inconsistency with the Constitution. The nature and extent of the charter violation lays the foundation for the remedial analysis because the breadth of the remedy ultimately granted will reflect at least the extent of the breach. The second step is determining the form that a declaration should take. Remedies other than full declarations of invalidity should be granted when the nature of the violation and the intention of the legislator allows for them. However, if granted in the wrong circumstances, tailored remedies can intrude on the legislative sphere. To respect the differing roles of courts and legislators, determining whether to strike down legislation in its entirety or to grant a tailored remedy of reading in, reading down, or severance depends on whether the legislator's intention was such that that is how it would have enacted the law as modified by the court. When an immediately effective declaration of invalidity would endanger an interest of such great importance that on balance, the benefits of delaying the effect of that declaration outweigh the cost of preserving an unconstitutional law, the court may suspend the effect of the declaration. The power to suspend the effect of declaration of invalidity arises from accommodation of broader constitutional considerations and is included in the power to declare legislation invalid. Suspensions of declarations of invalidity should be rare. The effect of a declaration should not be suspended unless the government demonstrates that an immediately effective declaration would endanger a compelling public interest that outweighs the importance of immediate constitutional compliance and an immediately effective remedy for those whose charter rights will be violated. The period of suspension, where warranted, should be long enough to give the legislature the amount of time it requires to carry out its responsibility diligently and effectively, while recognizing that every additional day of rights violations will be a strong counterweight against giving the legislator more time. When the effect of a declaration of invalidity is suspended, an individual remedy for the claimant under Section 24(1) of the Charter is in the form of an individual exemption from the suspension will often be appropriate and just. A Section 24(1) remedy should meaningfully vindicate the right of the claimant, conform to the separation of powers, invoke the powers and functions of a court, be fair to the party against whose remedy is ordered, and allow Section 24.1 to evolve to meet the challenges of each case. A court's approach to Section 24.1 remedies must stay flexible and responsive to the needs of a given case. The public is well served by encouraging litigation that furthers the public interest by uncovering unconstitutional laws. And claimants invest time and resources to pursue matters in the public interest. Thus, if an exemption is otherwise appropriate and just, claimants should be exempted from suspensions in the absence of compelling reasons not to. So ends Section 17, the final section of the Constitutional Law NCA Exam Study Guide for 2023. Best of luck on the exam, everyone. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.